Welcome to Coffee Chats with Klaas. Hi, I'm Eric Schwartz with Klaas Financial, and today I'm here with Kyle Kite, a certified financial planning professional, to discuss an area of financial planning that we often see people ignore: estate planning. I know this is a broad topic, but let's start with how Klaas Financial, or any financial planning firm, fits into the estate planning process.
First and foremost, we are not attorneys here at Klaas Financial. We don't prepare legal documents for clients, and we aren't licensed to give legal advice. However, we work very closely with many estate planning attorneys and collaborate with them to ensure that our clients have a strategy in place to accomplish their goals when they are no longer here.
I think when most people think about estate planning, they often think of a will. Can you provide a brief summary of the purpose of a will?
Absolutely. A will is a legal document that directs the distribution of an individual's assets after death. A will has no function prior to the death of an individual, and if a person dies without a will in place, they have said to have died intestate. So this means that there's no directives as to how their assets should be distributed. This requires the state to step in and determine the disposition of assets, which may or may not follow the deceased's intentions.
In recent years, there's been a lot of discussion of trusts. Where do they fit into an estate plan?
So like a will, a trust can be used to transfer assets after death. However, a trust can also be used to transfer assets during life. A trust is a legal entity that can manage assets or property for a beneficiary. Another attractive feature of a trust is its ability to avoid probate. And probate is the legal process by which a will is recognized and a personal representative is appointed to administer an estate. In addition to being a public proceeding, probate can also be time-consuming and costly.
Does everyone need to have a trust?
Not necessarily. For some people, a will is sufficient to transition their assets. In most cases, having a trust drawn up is more expensive than a simple will, so it's important to discuss the specifics of your personal situation with your attorney.
It's interesting that you bring up the cost of putting together an estate plan, because I know that is a reason a lot of people put off the process. How do you think about that?
We hear that a lot from people, not only from the standpoint of putting off getting an estate plan in place, but also from the perspective of whether to hire an attorney or do it themselves. The truth is that there are tools available that help individuals put together their own estate plan. And we've seen these programs work well for people. However, building out an estate plan can be a very complicated process, and hiring an estate planning attorney can help ensure that wishes are carried out exactly as intended. Working with an attorney can help save on taxes, navigate complex family relationships, and avoid costly mistakes down the road. In many cases, these benefits can outweigh the initial cost of hiring an attorney to build out an estate plan.
What other aspects of estate planning do folks need to be thinking about?
One very important part of the estate planning process, which often gets overlooked, has to do with appointing others to make decisions for you while you're still alive. So this is where powers of attorney come in, and they're often established in conjunction with a comprehensive estate plan that allow a principal to choose trusted individuals to make financial and medical decisions for them in the event of incapacity. A financial power of attorney document appoints another person to act on a principal's behalf in financial matters if they're unable to make decisions on their own. For example, a financial power of attorney may pay medical bills or sell investments on behalf of a principal.
How does a power of attorney apply when it comes to medical decision making?
Great question. A medical power of attorney document allows a principal to appoint a trusted person to make medical decisions in the event of incapacity. For example, a medical power of attorney may sign off on certain medical procedures or determine whether a principal receives life-sustaining care.
So based on what you shared with us, it sounds like the most important thing for people to consider is how will their assets be successfully transferred when they are no longer here, either through a beneficiary designation, a will, or a trust, and who should speak for them in the case of incapacitation, which can be accomplished through power of attorney documents for property and healthcare.
Exactly. Planning today for exactly how you want your assets to flow to your beneficiaries in the future is really important. We would encourage everyone to begin by taking the first step and review what you may already have in place or make a move towards establishing some new estate planning directions. Thanks for joining us for Coffee Chats with Klaas.